and the first one is focused on IP and competition policy. We have a really distinguished group of speakers and discussants who have been thinking about competition policy issues in IP for a long time. I will skip going through and giving you elaborate introductions to all of them because they're very nice printed brochures that do far more justice to them than I can, given the time constraints here. So please refer to the speaker profiles that you have. The ground rules are each panelist has 13 minutes, and be followed by the two discussants, and then we'll have a short Q&A session here, and then we'll turn it over, and we have about 90 minutes to do all that. So our first speaker is Dr. Geeta Gowri, who was until recently, a member of the Competition Commission of India, and she'll be our first speaker.
Good morning, friends.
Is this on? Yeah. Let's put one bit closer. I'm really looking forward to this session for several reasons, because there are people here whose views and opinions are something that matter to me and my understanding. Often may not agree with what I say, but also because the aspect of intellectual property law, the IPRs and the competition law, the Commission has to still work out an approach towards it. And this, I think, becomes very important when we have a crowd with different experiences coming here. And I thank the National Law University, both Yogesh and Arun, for inviting me and letting me make this presentation. Fortunately for me, there's another session after that where you will have very good economists, and the only thing is the best economists, they made him a chairperson. So we have to get more out of Professor Subhashish Kandupadhyay. I thought I'll speak. 13 minutes is awkward for me to figure out. I can work out on whatever you tell me when I should stop. It's a very odd number. Incentives and liabilities, intellectual property and competition law. Firstly, there's a strong relationship between economics and law. This is something that we are now slowly recognizing in India, which didn't occur in the studies that were taken, but the US has been more advanced on it, of getting it. Both function within bounded rationality, and I also think law based on economic theories must look at incentives and liabilities. That's why I've talked in terms of incentives and liabilities. I came in yesterday early morning for the first session, and I think the way we look at incentives and liabilities in competition law may be slightly different or may not be. It's a question of how you pose it. Markets function on incentives, and therefore in high-tech markets, which is where I'm going to look at the future markets, IPRs are very important, and they're critical that these incentives should be sharp. If decisions of the Commission, when I say Commission, I mean the Competition Commission of India, affect this basic incentive mechanism, then the liability falls not only on consumers, it falls on the economy. And therefore, when I look at incentives and liabilities, there would be a certain amount where I might digress from looking at the IPRs or any of the trade agreements, and also look at what happens to competition, because there is a certain interlink. The argument that intellectual property rights can create dominance, that's a very old argument, is the question has two aspects. One is treating the case as an abuse of dominance. This is something that the Commission has to always worry about. Because if you put it into the exercise of an abuse of dominance, then you continue to look at it as dominant, per se dominant, and per se abusive. And therefore, this is not a comfortable situation at all. Or perhaps, as some of the jurisdictions have done, they have preferred to let standard antitrust arguments stand by themselves and not extend the liability in terms of impacting technological development and innovation. I therefore, in these two parameters of incentives and liabilities, let me try to see how it comes up. Whether the fact that IPR owners are necessarily in a dominant position or necessarily monopolistic is now a little outdated, but then again one has to look at evidence. And I'll also take up the idea why competition law prefers the case of dominance and prefers the abuse much more than the other sections. Now, the reference of this lecture is on the competition law. I'm sure many of you may be a little familiar with the Competition Act 2002, but I don't know if you have it as a separate course or as an elective. But the fact is that there are three sections. One deals with agreements, both horizontal and vertical. One deals with unilateral conduct or abuse of dominance. And the last one is mergers and acquisitions, which is more an ex-ante assessment of unilateral conduct that takes place. The important thing, and this I keep emphasizing, is competition does not require to increase competition. There's nowhere in the law it says that you have to increase competition. All that the Act says, it only prohibits behavior that lifts competitive constraints on market power. So what has to be looked at is not on competition but on the behavior, and this is where I think we have missed the whole concept by defining competition in terms of the competitor and not of the consumer. Therefore, although there are references in section 4 and in section 3, it is on the question of how the behavior impacts. It's also very difficult to maintain the competitive process because everyone looks at outcomes in terms of rising prices, predatory pricing, but that's not affecting competition really. It has to look at the behavior and the constraints that come in. It's a very complex sort of argument, and what the Commission has been doing, which has been argued well by many of you in your article, is that they take all cases related to IPRs as within section 4, which deals with abuse of dominance, and assuming the dominance will prevail in section 3.4, which deals with vertical restraints. The argument given is that if you're dominant horizontally, you'll be dominant vertically. No arguments on that. But the abuse of dominance in one section doesn't necessarily mean it's an abuse of dominance of agreements. Although on terms of fair pricing and unfair pricing, some of my colleagues in the Commission believe it's the same. And this can lead to very awkward situations. Moreover, no attempt has been made to look at the safe harbor clause 3.5. And this is where I think many of you who are working on patent laws, or the Indian patent laws, would need to explore how it has to be handled and done with. I do leave a lot of unanswered questions. So, having stated this, as I said, my whole argument, I will take 3 cases very briefly so that it comes within the 13-minute gap, of which I must have finished 7 already. I will look at future markets. Why am I bothered about future markets? Is because of the fact that there is a scope. These are markets where dominance will be there, but it's a temporary dominance. There will also be the fact that technological change is very rapid and IPRs play a very important role. That's the reason why I thought I'd look at future markets. The problem about digitalization, which is really of future markets, is networks create depth. Platforms permit different pricing schemes on either side. You could have single homing on the other and multiple homing on the other, and advertising is the main source of revenue. Also, what is interesting is that I find some of the arguments that have come against dominant digital companies are very similar to the arguments that were held much earlier before digitalization took place, because the tendency of any regulator is to be bothered at dominance. It may be a legacy of the past, rather than looking at what are the competitive constraints that work on it. But the arguments now that they are posing as to why the dominance can continue is protected by patents, especially standard essential patents and standards of the standard setting organization, and access to data, algorithmic based, patent based. These are worries. But the kind of evidence, the kind of understanding that's required would need a certain amount of intellectual patents looking at it, competition law people looking at it and understanding it better, and more than anything else, one size does not fit all. It's a question of looking at it. The first case I took, I had discussed it last time I was at the NLAG, is the automotive sector and the aftermarket, which is a case of the vertical restraint. What happened in the automotive sector and the aftermarket was the Commission took the approach that the car manufacturer is dominant in its aftermarket. You know what an aftermarket is for sales and services and all that. Now, the Maruti being dominant in its aftermarket is axiomatic. It's absolutely axiomatic. It doesn't mean that there's anything about it. But what is important, and this is why I said if there is horizontal, you have to look at whether competition exists on the horizontal and not look at dominance only in the vertical restraints that come up. And in this, what was said is that the manufacturers or the OEMs control the original equipment suppliers through trade agreements, trade preferences, and perhaps IPRs, and therefore they were controlling the right, all because these rights were not being given to high specialty service centers. Now, when you look at it, the argument that went from section 4 to section 3 and the prescriptions given was determining strategies of firms in a competitive market was not important. The commission said all patents, all trade rights, all trade secrets must be shared. What is worrying to me is that perhaps some of these patents, which I was asking yesterday from Lakshmi Kumar and son, the patent might be taken in the US but not in India. Then this extraterritorial adjustment, how is it to be taken? And trade secrets too, why should we share? And I give you a very simple example. My cook makes the most excellent biryani, but when I ask her to tell me how you make it, she only tells me the content and not how it is done. See, I'm giving you a very commonplace, mundane example. But for people to share the trade secret is the commission going against incentives and the process of innovation and design. It's very important. Yes, you could talk in terms of a liability that other people are not coming into the market, but the entire automotive sector has become like before. There's so many people involved, and the paradigm has shifted from the earlier concept of the manufacturer having the control to perhaps people who are using artificial intelligence and coming in. What is also important from this case is that it is very necessary to look at contracts and agreements. If there is a contract or an agreement between an equipment supplier and an equipment manufacturer, what is the nature of the contract? What is the nature of the agreement? The next case, of course, which is the high-profile case which becomes important, was the question of the Google. The order is just out. And the Google, they decided, you see, when you're looking at dominance, what happens is, when I'm taking it from section 4 to section 3, I tend to define the market in a way my dominance gets established. In the automotive sector, we found the dominance got established for the simple reason Maruti or Honda would be dominant in its aftermarket. In the Google case, the definition of the market was, it was an online web search services in India and an online search advertising services in India, and trying to define it in multiple markets. The definition meant that there was a certain blurring of looking at where actually the abuse took place. Now, all of you can read the order, but the point that I want to try and bring it up here is that some of the recommendations that came in were a little similar to the automotive sector. And one of them was a question that despite these agreements that they had in the verticals, there should be a sharing of trade secrets, there should be a sharing of agreements. It isn't put forward so much in terms of IPR laws and all that, but my concern really is sharing of secrets and agreements. All trade and all business have to have some amount of secrecy. The issue is what do you share and how do you share it. And this then takes you to the question of the sort of algorithms that I use and whether the point of a business model which is based on advertising should then take off in other sections. They're very good articles because the order only focuses on one abuse, and that is the fact that Google, by going into verticals, had a situation of abusing its dominance. It's just a small shift. I think what becomes important for all of us is the language that is used. A vertical in the Google search engine is not the same as a vertical in an automotive structure. The argument given is that when you're going into another website, you click twice. But clicking twice doesn't make it a vertical. It is just a search engine which is trying to help a consumer want to know where to go and what is to be done. There are a lot of issues that are raised, and I would like to examine it further. Right now, today, I will just stop at the fact that the Google has raised issues on the question of sharing of algorithms. That was one of the recommendations of the Commission. The last case where the decision is still awaited is that of the SEPs, the Standard Essential Patents, and the set by an SSO standard setting organization. There are others who will go to details on it. But these are decisions which are still awaited. There have been a host of cases largely against Ericsson, and there have been also cases against Intel. I don't think there's a case against Qualcomm against the Commission. Now, the Delhi High Court has taken a certain decision, but the Commission has decided that further exploration is required because it belongs to the question of abuse of dominance, because an SCP will be a dominant player. So look at it this way. Section 4 is a per se judgment because if you're dominant, you can and shall abuse your dominance as market power. The IPR, by saying it's an SCP, you're presuming dominance, again a per se. So it's two per se's together, which makes life very simple. You don't need to bother to look for evidence, you don't need to look for analysis. The question then comes up, what sort of analysis do you look for? Are SCPs naturally, are presumed to be dominant? Are they dominant? And I was looking at some data, especially in the telecommunications sector. I think Jay has done a lot of work in this area, is that the question of innovation is so rapid that there are always new SCPs coming up, and there are new companies coming up, because like a honey pot, there are people who are wanting to get into it, finding new technologies. This may be different in a different area, but not in the ICT sector. But as a result, the evidence that one has to look into is how many SCPs are there? What is the similarity in the SCPs? Are there differences? Because each smartphone, each network has not changed completely. The telecommunication sector is no longer that lines and network and one phone standing there, but it's changed so much that the technology has been so rapid, it's extremely difficult to work on it. But the last point that comes up, which is the most worrying thing, is that on SCPs, the argument has revolved around FRAND. Fair, reasonable, and non-discriminatory. What is fair? What is reasonable? What is non-discriminatory? And this never gets defined because it is left to the subjective judgment of people who say this is fair, no, this is non-reasonable, this is non-discriminatory. Just because X is charged one price and Y is charged another price, is this necessarily wrong under the FRAND conditions? Or should one go into a different concept of how royalty should be set, what should be the base set? These are the sort of evidences that are required, and let us hope that the Commission comes up with guidelines on it. And I don't want to talk on the SSO because there are different SSOs there, and how does one look at it and what's their credibility. To end, I think what is important to establish when an antitrust or anti-competitive liability occurs is not an easy process in the high-tech market. It is very, very important to look at incentives and liabilities. Who is being incentivized and on whom the liability falls? And unfortunately, all cases that come to the Commission come from the domestic competitor. And I think it was mentioned yesterday, I don't remember whom, by taking up a case for a domestic competitor who would be a large organization within this country, maybe not large with an international company, the Commission inadvertently lands up protecting the competitor and not protecting the consumer. So whenever there is a liability, then one has to look through and see how it is to be addressed, and that the incentive mechanism should not be ruined, And I think it is here that it becomes important to look at the question of clarity on trademarks or agreements, even on patenting. What is the sort of incentive and liability mechanism of IPRs in the competition law? Should it be in alignment, or should each come of its own, but evidence becomes important? There should be a further discussion on safe harbors, which is your section 3.5, and how it has to be handled, and the question of how to encourage innovation within this country, and that becomes important. And my worry with all the three examples I've given is, including Google, it is not the startup which is going to get the benefit of going in for a patent bridging. It is a question of a large domestic competitor trying to get more of the surplus than letting it go too further down. Thank you.
Thank you, Dr. Garg. Our next speaker is Mr. Alvaro Ramos, who is a Senior Director and Head of Global Antitrust at Qualcomm.
Thank you, Professor. So in the next few minutes, there are three aspects, three elements that I want you to...
Can everyone hear Mr. Ramos?
Sound okay? Thank you. So in the next few minutes, I want you to come out of this conference having a clear understanding of the relationship between IP and antitrust, and to that end, I'll give a brief introduction on antitrust, and followed by how it relates to IP, and then focus on the standard setting organizations and talk about the issues that you are hearing about hold up, hold out, royalty stacking. Hopefully, at the end of this intervention, you will be able to form yourself an opinion of whether these are issues that raise antitrust concerns, or whether there is not real antitrust concern. Excuse me. So let me start with antitrust and start with a question. If I were to ask you, why do we have competition rules? Many of you are students, some of you are professors, but if I were to ask you that very simple question, it is, and if you don't use the word competition in your answer, but why do we have these rules? It's actually a question that is more complex than it looks at its face. The fact of the matter is, we have competition rules for one very simple reason, is that people like you and I want to pay less for things. But competition law does not protect the outcome. It doesn't say that you have to pay $2 for this bottle. It says that there should be a competitive process that gets you the water at the best possible value. So competition rules do have a clear objective of bringing you better products at a lower price, but they protect the competitive process. The competitive process is restrained, for example, when two companies decide to fix prices. That is inherently anti-competitive. Instead of competing, they agree to raise the value of something. It is bad for you because you ended up paying more for that product. Okay? In terms of unilateral conduct, the unilateral conduct or abuse of a dominant position is bad in terms of the competitive process, because it is altered in a way that pushes out a rival, which in the medium term, will result in the monopolies being able to raise prices above a competitive level. So now that we understand, the objective of antitrust, then the objective of competition law is not so much to create competition, but to protect the competitive process. So it is, in my opinion, the role of competition agencies is not to play God by trying to re-engineer the market and decide whether more competition should be created, but ensure that that process is respected. So let's move to IP for 1 second. So an IP right is essentially, it's the right to exclude. It's been defined, in my opinion, wrongly, but I think it helps to understand the concept that it's a legal monopoly. It means that you're the only person that can use a certain technology that is widely available in the market, and you have the right to authorize others to do it. But as such, you know, you're every time somebody incorporates that technology, you can either exclude them or ask them to pay a license for that. So with that in mind, let's talk about. So you can see there is some tension between the objective of competition rules, which is to promote competition, and IP, which is precisely to restrict competition in areas that you have patented. The idea being, obviously, that competition takes place before the IP is registered, the patent is registered, so that it promotes R&D and innovation, so that people compete to patent a certain technology, and that's where the competitive process occurs. Once you register that IP and it's a valid IP, then you are entitled to obtain the rewards of that competition. So let's move to standard setting organizations. You've all heard about standard settings organizations and all the problems, all the antitrust problems that they create. But let's look a bit more into it and understand whether there's a real issue or not. So the way standard settings organizations work, and let's talk about cellular for 1 second. I'll be obviously referring to some of the issues that Qualcomm has open, but I need to obviously clarify that I'm speaking on my own behalf. And on these, on standard settings organizations, companies that have technology that they think they can contribute to a standard, for example, 3G or 4G, meet and decide which technology should be included in this standard. It is a process where you exclude technology that you don't think should be good for this standard, and obviously once you make it to this standard, then that gives you an ability to charge for that IP. That process in itself, and I'm sorry to say to all of those people that have quite a bit of an issue with that, works actually really well. It groups many companies, hundreds of companies around the world, to decide on how to create the best standard, so that, you know, phones talk to each other, so that you can download a picture from the internet, so that you can do all these great things. The amount of technology that goes into that is quite impressive. The business model of companies that contribute to this standard varies quite significantly. Ours, for example, is one where we invest heavily on R&D to make sure that we have the best technology. We then go to the standard, persuade others that they should adopt that technology, and once it is adopted, we obtain royalties for that. Now, here's the first thing that you will be hearing about the standard settings organizations that raises a concern: the risk of hold-up. And what is hold-up? Hold-up is defined as the ability to charge above competitive prices once your technology is included in this standard. Let me give you an example. If today we all agree that we should have a certain technology that we are all using, and then I have IP, and once I learn that that IP has been included into the standard, instead of charging you $1 for my technology, my price becomes $100. By the time you learned about the price that I am charging, you know, you've already made all the investment into that technology, so it's too late for you to sort of go back to the standard and choose a different technology, and I get to charge you $100 instead of $1. Now, is that bad for competition? Does that result in higher prices? Is that something that we should all fight? I think it's fair to say that that's obviously a bad outcome. But the more fundamental question is that happening nowadays? And the answer is no. Let me explain you why that doesn't happen. When you sit in a standard, number one, you disclose how much you're going to charge for your IP. It is not something that companies discover years after. So people know what it is that they're getting themselves into. When you have different iterations of the standards, so you have 3G, 4G, 5G, not only they know how you charge for that technology, But they can choose in the next iteration of the standard to exclude you if they think that they don't like that you charge excessive pricing. Now, the only once your standard, but again, one point that is also quite important is that most companies that contribute to the standard disclose upfront how much they're going to charge. So once you start licensing for once that technology is included into the standard, you start licensing quite broadly on front terms, and what that means is that you cannot refuse to license that technology unless there's a disagreement, there's certain limitations in your ability to seek an injunctions, and as a matter of fact, if you ever try to seek a royalty that is unreasonable, the licensee can simply take it to court. Your ability to seek an injunction against that type of licensee is extremely limited. There is, in my experience, no real cases where a licensee has been foreclosed from the market. And let me tell you why that doesn't happen. It wouldn't make sense. If I start playing games with this standard, and I start charging too much, I start discriminating, I start making life difficult for people, and that puts into question the success of the standard, what do you think is going to happen to my investment? Because think again, the risk of holdout, in my opinion, doesn't happen, but there's another risk which will hold out. And here's what can happen. Remember all this investment I've done in this technology? Then think for 1 second that I am not going to recover that investment until many years to come. At that point, if licensees simply stop paying, I have to take them to court, I have to fight them, and it's going to be a painful process. Their ability to obtain a lower royalty from me so that I can avoid all of that is quite significant, because I have to obtain a return on my investment. The risk of holdout is actually very real. We see it every day. We still have a couple more minutes. So let me maybe end with one question that you might be hearing, that you might be wondering right now, which is, so if the risk of holdout is not there, and then what is all this fuss about? It is quite simple. A few years ago, a few companies decided that they thought they were paying too much for their royalties, that IP was just too expensive, and decided to get together and said, we need to change the rules. And they went around to different agencies around the world and thought, well, if I can persuade an antitrust agency that I am paying too much, I can move the goalpost. I can reinvent this machine and tell the company to charge less. There's nothing more pro-competitive than asking somebody to charge less. That's good for consumers, isn't it? It isn't. Trying to shift the bargaining process and the outcome of the standard setting organization process years after the standard has been adopted, based on rules that were known in the market, is something that might result in lower royalties in the short term. It is certainly not good for innovation. It is short-sighted, and it's something that we will pay for many years to come. Thank you very much.
Our third speaker is Professor Vikas Katuria, who's a professor at Bennett University, and I've got some slides up there.
Hi. So, this topic is a little theoretical, in the sense like I can talk a lot about intellectual property and competition law interface, but Yogesh asked me to do something theoretical, in the sense why competition law should accord a differential treatment to intellectual property as compared to the real property. Well, the life is very difficult in competition law because there are so many things to do, especially when the business models are transforming from brick and mortar to online. Some say they are challenging the very basic, essential features of competition law. So, but this is a question which does not come very often in competition law regarding the differential treatment between IP and competition. So I'm just giving it a try. It's not comprehensive. I don't claim it to be comprehensive, but it sets at least a background for further work. Okay. So let me start with this, right? Why is why is IP different from the real property? What are the characteristics that differentiate these two properties, right? First, IP as a property right for a limited period is recognized to reward the innovators for the creative or inventive step. This is the reason why IP rights are granted. Yesterday we had lengthy discussion, so I don't want to spend much time on it. We are taking the things as they are. Now, well, this is not the case with the real property. You know, this is the sole reason why we organize ourselves as a state, right? Because we want the state to protect our life, body, property. So we have certain emotions with respect to the physical property. Of course, there is an economic argument, but incentive to innovate does not per se come in when we are talking about physical property, right? Now, why? What is the difference between IP and real property? There are definitely differences and they are recognized. Even in the literature, in the guidelines, everywhere they are recognized. So I think these are the four basic differences between intellectual property and the real property. Look at this. Intellectual property, of course, if you look at any form of intellectual property, including patent, they are accorded, they are recognized for a limited period. Say, for example, 20 years. Which is very often not the case with physical property, okay? We have perpetuity doctrine in physical property, but that's a different thing. It has a different application, right? Now, second, often no protection in case of parallel creation, copyright and know-how. I don't think I have to enunciate upon it. It is a differentiating factor between intellectual property and real property, okay? You can have two similar plots of land, identical, same, right? But this cannot be the case with copyright and know-how. Now third, if they fall in public domain, if they become public, they lose the value, intellectual property, which is definitely not the case with respect to physical property. You have laws, right? You have tortious claims like, you know, trespass, etc. Nobody can venture onto your property. You can safeguard it. And fourth, which is a very fundamental difference, ease of misappropriation. It's quite easy, right? When we are talking about intellectual property, it's quite easy to know about it and to misappropriate it to your benefit and to the other's detriment. So let's start with these fundamental characteristics of intellectual property and then build upon it so far as their treatment in antitrust is concerned. Now, look at this. So I have taken these characteristics one by one and tried to analyze. Now, limited period. So does it mean that the competition law should be giving more protection? That means there should be, you know, lesser application of competition law to intellectual property because, you know, unlike the physical property, it's given for a limited period of time, say for 20 years. Well, it makes sense, right? When a right is not absolute so far as the temporal considerations are concerned, should it make or does it make a valid ground for a differential treatment in competition law? Well, look at this. Even within the limited period, abuse of IP rights can be detrimental to the consumer welfare. I grant you the right for 20 years, but even within these 20 years, there can be problems, right? What is the reason that this right is recognized? Because short-run consumer welfare losses can lead to long-run consumer gains. And mainstream economics proves it, now probably beyond reasonable doubts, that definitely innovation is more productive. Short-run gains are probably not as lucrative as the long-run gains. So there is a reason to identify, and innovation is a parameter, is a factor of development, okay? Now, but having said that, we know that even within these 20 years, abuse can definitely happen. Now, what's the other point? This can be in case of excessive loss to static efficiency. Mind it, when a jurisdiction is recognizing a legal monopoly, the bargain is there. This is the first bargain, right? When the innovator says that, listen, I need to be incentivized. Okay, we are incentivizing you by giving exclusion, right? Look, completely a legal monopoly. So that's loss to static efficiency. We recognize it. But is this what you had bargained for when you start abusing it? Say, for example, you start overpricing your product much above the marginal cost. Now, this is something which falls within the realm of competition law. We call it exploitative abuses. Okay? Now, this is something which the IP regime had not envisioned, right? The ball is not in the IP code, it falls within the ambit of competition law, and life is very difficult when in competition agencies we have to determine whether the prices were actually exploitative or not. There is no perfect economic model. Well, European Commission, European Court of Justice, they say that you should employ as many methods as possible in order to determine if the prices were actually exploitative. The best method is that you start comparing the prices, which happened in the Merck case and one another case which reached to European Court of Justice. It's a Latvian case, it's a recent case, right? I can share the name with you, I don't remember it now, right? So, what's the second thing, right? Exclusionary abuse. Why do I exclude my competitors from the market? What's the reason? The idea is that once I do not have anybody to fight with, I will be increasing the prices. You see? So the end result is the same, that I want to reap supra-competitive benefits through two different means. And this is when the abuse of IP rights can happen, even within this limited duration of 20 years. And that's when competition law comes in and says that, listen, you just can't do it. And there is no carte blanche, right? Even so much so, Section 3.5 of the Indian Competition Act, people hate it. I don't know why they do it, right? So if you look at Section 3.5 legally, a complete legal analysis, look at it, it just says that, listen, there is no presumption against intellectual property. They have to be analyzed. If you remove Section 3.5, it would make no difference whatsoever, because modern competition law, mainstream economics says that there is nothing which is per se, so far as the application of intellectual property is concerned. So much so, look at this, grant bags. If I have a provision in my IP licensing regarding grant bags, US DOJ guidelines, 2017 latest guidelines, they said that, listen, they are not per se bad. There can be pro-competitive reasons for grant bag conditions. So 3.5, please have a look at it. In my view, 3.5, even if it is a goodbye, nothing changes. Okay. The last point is, or when dynamic efficiency is jeopardized. Now look at this. I think it's a very simple point, but a very effective at the same time. A jurisdiction accords legal monopoly. Why? Because somebody did something which is good, which is innovative, which is good for development. Okay, I recognize it. But there can be a situation when this legal exclusion, legal monopoly in itself is leading to stifling innovation. Follow on innovation. Well, stand on the shoulders of giants. We know this, we have heard about this so many times. But what if the giant is not letting you use its resources? That's when the problem arises. Okay, and then you have to align the right kind of incentives, and that's when the European approach comes to. You look at the long line. I'm going to talk about it in a bit about it. IMS, McGill, and Microsoft cases, the 4-pronged test. That, listen, I can compulsorily license only in exceptional circumstances, and one of the circumstances is that refusal to deal should impede the flow of new product on the relevant market. This is how you are aligning short run and long run. Okay? So in these kind of cases also, competition law can come and say that this legal exclusion is leading to stifling dynamic efficiency. This cannot happen because competition law is merely a process. It's not an end. The end result is efficiency, and definitely all these efficiencies are not aligned. There will be difference between static and dynamic efficiency, and this is for the jurisdiction to make a prudent choice. Okay? Now, next slide. What are the other reasons? Not protected against parallel creation. So, does it mean that I should be more respectful towards intellectual property in competition law application? Well, not a valid argument for a differential treatment in competition law. Exclusivity is not an issue. In competition law, when we are dealing with intellectual property, we do take it as property. There is nothing which is at stake except for this exclusivity and the concomitant detriment to consumer welfare. Maybe it could be a reason to think about, it could be an issue in intellectual property, but not so far as competition law is concerned. Well, related to this, we have the fourth point, may lose their value if become public. Once again, this is not something which competition law is concerned about. If it has been alleged that this exclusion is leading to abuse, it means that you are dominant in the first place. There are no parallel creators. Okay? So the application of competition law has already been invited by the mere virtue of market power that you have gained. Wonderful. So now the last one, ease of misappropriation. Once again, in competition law, the issue can be related to the abuse of IP, not of its misappropriation. What we look at competition law, three things we primarily focus: anti-competitive agreement, abuse of dominance, and mergers. So far as IP is concerned, predominantly 102 TFEU Section 4 of the Indian Competition Act, how it can be abused, how it is abused. So far as its misappropriation is concerned, there is a civil regime. You can go and pray to the court for a civil injunction. Okay, this is something which competition law does not deal with. For all these reasons mean that there is no real need to treat intellectual property any different from the real property in competition law. Okay, now let's look at the practical side. What actually happens on the ground rule? Well, DOJ, so far as the Department of Justice and FTC antitrust guidelines, the latest guidelines of 2017, sorry I haven't mentioned 2017, but these are 2017 guidelines, they say that they recognize that IP has special characteristics, but these special characteristics do not warrant any different treatment to intellectual property. Well, the regulator should be mindful what are these different characteristics, but does not per se in itself makes a different treatment case for intellectual property. Well, I'm quoting from the 2017 guidelines. An intellectual property owner's right to exclude are similar to the rights enjoyed by owners of other forms of private property. Okay, so this is the first part of my presentation. Now, well, there was a question regarding standard essential patents. Are they different from other intellectual property? The theoretical and the practical answer is no, a big no. They in competition law have the same value as any other intellectual property. Then why do we frown upon it? Well, it is because there is a harsh reality that the moment you are accorded standard essential patent status, especially in certain fields, not in all the fields. Imagine telecommunication field where the standardization process happens on the global level. By the mere virtue of the process and the technology, this SAP status is giving you a dominant position more often than not because there are no competitors to compete with, which may not be the case in other semiconductors and other patents. Okay, there can be more than one standards at the same time, but not with respect to standard essential patents in telecommunication sector. And it's all about bargain. The first bargain is when you go take your patent to the patent office and says that, listen, I have innovated. Okay, 20 years, this is the first bargain. The second bargain is that you won't be unfairly using your patent. This is the second bargain, once again, in the patent statute. The third bargain is that you won't be abusing your intellectual property. Holding an intellectual property in itself is not abuse, but you won't be abusing. This is the third bargain which happens in the competition law. Yet, there is one more bargain. This bargain happens when I take my standard to the standard development organization and say that, hey, listen, I commit that I will be licensing this particular standard on fair, reasonable, and non-discriminatory terms. This is one more bargain which brings the application of different legal regimes into picture. It's a contractual obligation to the obligation to the standard development organization. Along with this contractual obligation, there also exists competition law application, abuse of dominant position, and civil law remedy of intellectual property. So we have three different regimes when we are discussing standard essential patent. So far, we have seen standard essential patents primarily from the prism of competition law. But there is definitely at least a theoretical need to also explore if contract law could be a valid remedy, because if you are not licensing your technology on fair, reasonable, non-discriminatory terms, you are violating your commitment to the standard development organization. Different theories, privity of contract, etc. come in. One needs to explore these points, right? And one very fantastic case would be Unwired Planet, like last year, April 2017 case to begin with, so far as the application of contract law in SAP is concerned. Okay, wonderful. Now, after this, it's a little bit more. How much time do I have, Professor? Okay, so I'll quickly wrap it up, just 2 minutes now. So far as refusal to deal is concerned, intellectual property. Now the first part is like, I look at the US treatment, US, listen, I'm not going to poke holes into intellectual property rights. It's sort of like sacrosanct after the Colgate back in 1919 and Trinco case, it is set in stone. I'm just wrapping it up, I don't have much time, we can talk about it later. EU, they aligned it in exceptional circumstances. I can compulsory license your technology. The test, which is one of the 4 tests, is like new product requirement. If you can show that by licensing intellectual property of your competitor, you can bring in a new product on the market, we are ready to do that. How about developing countries? Now listen, developing countries, innovation argument, one has to be skeptical about. Mind it, once again I'm saying developing countries, it's a big bracket. It's a huge bracket. All developing countries are at different stage of value chain development. So there cannot be a generalistic prescription. Innovation is a complex ecosystem, systems of innovation approach, right? New Schumpeterian approach. It's not a linear thing that you pump in money and resources at one end of the pipe and innovation, a new product comes from another. It's extremely complex. Hundreds of years of research has gone into it. We are still trying to understand. All these institutions interact with each other and the resulting end is innovation. You can say that, listen, patents should be recognized in developing countries, but the idea is institutions are missing or half developed or not developed at all, innovation won't happen. So in the absence of the supporting infrastructure, this incentivizing innovation argument does not hold much water, at least in developing countries. So licensing, compulsory licensing can happen, and so far as the TRIPS is concerned, a legal analysis, Article 8, Article 13, you can have a look at it. They do not impose any embargo so far as compulsory license and competition law is concerned. Thank you so much.
So we'll now turn to our discussants, Mr. Ashutosh Kumar, who is an associate partner at Singh & Singh, an IP law firm here in Delhi.
Am I audible? Yeah. Morning, everyone. So I am replacing CIIPC here, but views are purely mine. Thank you, panelists, for a wonderful presentation. Yeah. I will love if CIIPC has share the same views as I. So I have a few comments on everyone's presentation. I'll start with Dr. Gori. I say that you laid down a very good test and guideline for regulators how to deal with cases when it comes to IP and competition law and the test of incentive and liability relationship. And you wonderfully pointed out that while dealing with these cases, one should look into whether any act or any order passed by commission will kill the incentive and who will bear the consequences for killing that incentive. It's ultimately it's consumer or it's the IP owner itself. Incentive-based approach is also relevant because IP and competition, they share one common goal of enhancing dynamic efficiency. So I think CCI or any competition regulator should take this into account while dealing with cases where the IP issues is involved. Whether my action will send a message in the industry that IP rights are not that important for the commission, and when that in short term you may gain us reduce prices or something, but in long run whether that will kill innovation or not. Second thing which was highlighted in your presentation is about the ignorance of importance of trade secrets, and it seems that Competition Commission of India is of the view that only statutory protected IP rights are IPR and not common law protected rights are IPR, which is very strange because by that logic even a suit for a passing off can be considered as abuse of dominance, because in that suit you basically asked for excluding a competitor from using your IP rights, which you feel that it's, even though not registered as a trademark, still protectable in a form of goodwill. So that's two very important things. I think we still need more clarity how the Commission will treat trade secrets in future cases. We hope that in future we'll see some more cogent reasoning by Commission on this aspect. Coming to Alvaro's presentation, thanks for clarifying that the role of competition agency is to protect the competitive process and not to enhance competition. And you also highlighted the problem of hold up and hold out, and which is the real problem and which is the theoretical problem. I have one small comment on that, this entire problem of hold up or royalty stacking actually started in theory. It was not a problem which industry was facing. If I'm not wrong, and correct me if I'm wrong, it all started with one article in 2007 by Professor Mark Lamley, where he said that in SEP cases and FRAND cases, there could be a problem of hold up. And that became very popular, that concept became very popular. But in the same article, he mentioned one more thing, that for hold up, if there will be a hold up problem, so we should dilute injunctive relief because that may facilitate hold up. But in the same article, he also mentioned that diluting the injunctive relief won't harm patentee's interest because we have a provision of treble damages in US. So there are two things which are very important. First, was a theory discussed and developed in the context of US patent. Now tell me, in how many jurisdictions there is a concept of treble damages? Only US. In India, we don't have that concept. So if you don't give injunctive relief to an IP owner or to patentee, is left with the damages, normal damages, and for which he'll have to fight for 10 years or 20 years, especially in jurisdiction like India. That created the problem of hold out. So in order to solve an imaginary problem, you created a real problem, which is a hold out. And we are seeing more and more example of. I haven't seen any case in which the court have said that there is a finding of hold up, but I've seen last year, as Vikas also mentioned, Anwar Planet case, in which the court came to the conclusion that yes, there is evidence of hold out. So that's my take on this issue of hold up and hold out. I hope Commission in India will take this, will consider the industry reality and the market reality of especially the mobile phone sector in India while discussing all this concept, because in India in 2013 CCI flagged this issue of hold up and said that there is a problem of hold up, and right now we are in 2018. The Indian mobile phone industry is the second largest market in the world. So the empirical evidence suggests contrary to what CCI said in 2013. So now coming to Vikas' presentation, I have two comments and one question. You discussed, you explained the fine distinction between the real property and IP property and whether competition law should treat them differently or in the same manner. One thing you suggested that overpricing, even during the term of IPR, can be considered as abusive. I just want to ask whether that you said in the context of essential facility, if an IP can achieve a status of essential facility, then overpricing will be abuse of dominance, or it's okay even for normal IP, because there's a argument that grant of patent actually is an opportunity to charge anti-competitive prices. It's only when that patent right or any form of IP right achieves the status of essential facility, then IP owner has some kind of an extra burden to charge a reasonable price or not to charge too much or excessive pricing. So that's an argument, I'm saying. So maybe you can throw some more light on that. And the other important thing which you mentioned, it's a role of contract law in dealing with FRAND cases. It's very important, because in breach of FRAND, and when we say is a breach of FRAND may have some competition law issue, there are two things: breach of FRAND obligation and the impact of that breach. Till the time it's breach of FRAND obligation, I believe it's falling purely in the domain of contract law. It's your contract with your standard setting body for the benefit of implementers. An implementer as a beneficiary can file a suit for breach of contract like Microsoft did against Motorola. If we have one example in India as well. And whether or not that breach has taken place, that can't be determined by competition agency. Let that leave for civil court to decide. And then if the civil court comes to the conclusion that yes, there is a breach has taken place, then you see whether that breach has affected the competitive process in the market or not. So, but in India, we still don't have that clarity, and in future, maybe in cases we'll get that clarity. But overall, all these three presentations highlight that the industry still need clarity how to deal with cases in IP-related cases where the competition law issue has arisen. And in India, not only we have a problem of uncertainty on how to deal with these cases, but also who will deal with these cases. So the jurisdiction challenge is pending in Delhi High Court. Why we have this problem? Because unlike US, Europe, and UK, civil courts don't have that concurrent jurisdiction of dealing with competition law issue as well. And we have a very strange provision, section 61, which exclude the jurisdiction of civil court, saying that civil court can't look into competition law issue. But that section ignores the fact that in a lot of IP matters, there can be a competition law violation defense. And it happens in a lot of matters. Now it's a very strange position that if an IP owner files a suit and a defendant wants to raise a defense of breach of competition law, that defendant will have to approach another forum. So you're defending yourself in an infringement suit before another forum. How you will reconcile this thing, I'm not sure. They'll bound to be some kind of a conflict of opinion between two forums when two forums deciding the same case. That issue is pending. We hope sooner or later that will be decided. But one test which I feel can be applied to deal with such kind of situation, and it happened again in Advair Planet case in 2015. Before the final judgment, Justice Bliss also passed a judgment where he faced the same situation, where the defendant said that there is a competition law issue, you refer the matter to competition authority. He said that no. The predominant issue in this case is related with patent law. It's infringement of patent, it's a validity of patent, it's a royalty rate determination for patented technology. So he said that because the predominant issue is related with field of patent law, I'll deal with even competition law cases. I feel that that test of predominant issue can be applied in India to deal with this situation, and I think that can be applied in different sectors as well, because even in telecom sector, we are seeing that two regulators are fighting each other on jurisdiction. Whether TRAI has a jurisdiction or Competition Commission have a jurisdiction on trade pricing issues. So that can be applied even in different sectors as well. Is anything else I should mention? On how to deal with this, the IP and competition law related issues, I think the test in that context which can be applied is test of determining whether an IP owner has exceeded the scope of his right. So for instance, a grant of patent confer a right to exclude. To right to exclude, you can file a suit, and instead of excluding, you can also grant a license. So you have a right to exclude, you have a right to seek royalty in lieu of granting a license. That's the scope of a patent. Now, if you exceed that scope and you do certain acts which is not protected by your statutory right, then there may be a competition law role to play and to check that particular act. And there is one case in India which I think where the CCI is finding that fine distinction between scope of a right of a patentee and any act which is exceeding that scope. That in-phase case, where the issue was involved that one party filed a suit in Bangalore for infringement of a patent. Also wrote to the suppliers and customers of defendant that this particular company is fraud and you don't deal with this company. Now the CCI has said, CCI instead of has said that the abusive conduct here is writing to customer and supplier and not the filing of suit. So that is there. I think we are getting that clarity, and we hope that in future there will be more clarity. So that's all I have to say in this. Thank you.
Thank you very much. Our final discussant is Mr. Pranav Mehra, Principal Legal Counsel, Snapdeal.
Thank you. I think when you have a brilliant panel and the speakers are excellently well prepared, you seem to have a real challenge sitting on the desk listening and probably trying to justify your presence here, which is exactly what has happened to both of us. He's brilliantly summarized whatever the three speakers said, and I'm left with almost nothing much but my own innovative points, which probably should have taken or could not find mention in the limited time period we are here. I think first of all, the whole discussion about the IP and competition policy is more focused on the patent aspect of it. If you're on a real world, apart from mobile and telecommunication service, nobody really has a issue with patents and competition law as such. And real life problems revolve around unfair use of trademarks and unfair use and unfair competition, unfair trade practices, consumer policy, and all of that. Which is where the concept and the presence of online markets make it more difficult, because you have a two-sided market, the IP holders on one hand and the buyers on the other hand, and people wanting to sell either a counterfeit or an infringed product, and what you do as an intermediary becomes more complex when you do not know who is the real owner. And that could also be something of discussion, because in terms of an intermediary wanting to promote competition, which would mean having more competitors for one brand of products online, and therefore prices would really be competitive, you are faced with a situation wherein a trademark owner is wanting the other sellers not to sell the same product, and not saying it's an infringed or a counterfeit product, but he says it's not something that he is licensed to the seller. Now, in terms of a brand, the principle of exhaustion applies in the sense, once you've sold it to the wholesaler, you can't limit it to who the wholesaler sells afterwards. So it could be the retailer, it could be the importer, it could be anybody. But in the setup of an intermediary, it becomes very difficult to answer what to do in the limited context, because you have a time period to adhere to under the Information Technology Act. You have a takedown notice, which is not so well prepared by the brand owner, but you still have to take a stand. So that discussion on the IP and competition law should also be discussed from the trademark perspective of it. I'll probably now come on to the copyright and competition law perspective of it, which sort of was discussed but not discussed in length, wherein softwares which get copyrighted and not patented are somehow left from the discussion. Maybe something that the panel or something that the center could probably look into it. You could have software which at some point of time would become an essential software, and at what point of time will that essential software be sold at what price becomes very difficult for a brand owner to justify, because he would not know whether it's his essential software. It's a licensed software, and the license pricing would go up every year, and therefore one could really challenge whether the price has become excessively high and bring a case. And therefore the case itself to defend becomes a very costly affair when it goes to the Competition Commission, and therefore you have a writ pending in the High Court for injunction, you have a IP case going on the IPAB, therefore a lot of multiple lawyers have to be involved, and from an industry, for a company who's done nothing really, the cost of entire setup becomes too costly for the company. It affects its revenues, in fact. Therefore, that discussion could also be looked into it, whether a software, a copyright, whether registered as an IP or not, could be essentially be challenging the competition law principles at some point of time. Then Madam Gauri, as always, brilliantly probably discussed everything in the entire world, from automotive to online to pharma to SEPs, and I think a brilliant speech in the limited time period she had. I had a few points wherein the Shamsher Kataria, the automotive case, was discussed. And in the case, the Commission has noted that the IP, the Section 3.5 exemption can only be given if your IP is registered in India. And if you probably go through, the automotive companies failed through that exemption because their IP was not registered in India, which necessarily, if you read through, doesn't really mean that if your IP is registered in India, you would get a protection under 3.5, because 3.5, the exemption under competition law, also says reasonable conditions as necessary, and therefore the word as necessary becomes a little too difficult for a company to justify when they impose reasonable condition. At one point of time, would it be necessary to impose those conditions which also should be reasonable? And therefore, I think the panel, therefore, and Ashutosh for one, really spoke on whether on the need for more research and more scope of dealing with 3.5. I think somebody in the panel said that, I don't remember who, but that was a point well taken. You also have the unfair enrichment, unfair just practice which happens when there is a import of parallel product. It's a branded product, but not by the trademark brand owner, and therefore you have unfair competition wherein the Indian brand owner has paid all the taxes, but there is a importer who is probably not paying half of it and only pays about custom duty and has a very good scope of price fluctuation, and therefore it affects some part of competition, although competition law inherently will not deal with it, but it's a competition issue. However, neither dealt under the Competition Act nor under the other acts. It's pending with Supreme Court for some time, and I think that discussion should also be noted down. Vikas started with the statement that the presentation may deal with the online market. However, I probably didn't say. To me, when the topic was provided and I was asked whether IP as a property and competition policy, how will that reflect? And I'd given a thought, and this thing that came to my mind was IP is a property. Why IP? I sort of missed the discussion yesterday, but from a competition perspective, you have always IP as an asset in the balance sheet, and therefore assets and turnover is something that is looked by the Competition Commission from a merger perspective. You also have assets to be looked as a factor for determination of dominance, and therefore abuse of dominance factors kick in when you have an asset, and therefore at some point of time the valuation of that IP of that asset becomes very, very important. Becomes important from transfer pricing, becomes important if your subsidiary owns it. It becomes important if you're wanting the subsidiary to be acquired by somebody and the subsidiary is only holding that IP, and therefore whether you would want to file a merger application with the commission, because it's the IP valuation that counts and not the company's total. So therefore these discussions are a real challenge in the industry perspective, where there is no clear answer as to what really is a clear guideline, what kind of licensing practices are best practices in India, but you would know what practices are not the best practices, and therefore if you want to have a negative covenant or a positive covenant towards your right, and if it may become a challenge at some point of time. I'm not touching the SCPs and the patent because it was predominant in the entire discussion, and I think it's majorly covered. Madam Gauri talked about the advertising business model, which I think also touched about the future markets she was discussing about, and therefore how Google operates or how even an online intermediary operates is very important, because you have an advertising revenue coming from the people who are clicking the link or just by the banner display, and there's a IP holder of which the banner is being displayed. Sometimes there could be competing companies in the same advertisement. It could be one after the other, and some of the companies would not want their advertisement to be just next to the advertisement of their competitor, because it will lose the value of their product, which becomes important whether you need to accept those kind of anti-competitive clauses in the contract that you're entering, or whether having a delayed period or having a set timeline which is not working automatically is good under the competition law, something that also needs further discussion. Network effects, brand algorithms and automation are something that we all need to probably research more on. FRAND is being contemplated, being discussed at Europe, at the US, but there is this new form of challenges that the industry faces, wherein you have different competitors and different points of view from a vertical or a horizontal chain, and you as an intermediary are in the middle of that entire plethora of the mess. And therefore, if you take one stand, you become a party to either a cartel, or you become a party to the vertical restraint that the company is wanting to. And therefore, from an online intermediary, it becomes very difficult to probably be neutral for a very longer period of time. And if that remains to be, it probably is on the verge of losing a revenue which could probably come if they join forces with somebody. And therefore, that itself is a very difficult task and a risk that involves a lot of monetary penalty. I think I will end there and probably open the panel for discussion again. Thank you.
Thank you very much. I want to make sure that I give the speakers a chance to respond, and please respond briefly, because I want to make sure the audience has a chance to ask questions. So if anybody has any specific points to make in response to the discussants, please go ahead and keep it brief. Any of you? Any of the three of you? Okay, good. Then I want to make sure that I give the audience a chance to ask questions. If anyone has, make sure you get a hold of the mic so we can hear you clearly. Let me start from here up front, and then I'll work my way back to the room. Ma'am?
That's okay.
And you can ask questions to any specific person or to the entire panel. That's fine.
Good morning. I'm Akanksha Kumar. I'm a doctoral scholar at the National Law University, Jodhpur. My question is addressed to nobody in particular as such, and it kind of builds on something that Pranav and I were discussing yesterday, and also David and I were discussing yesterday. And it's about pay-for-delay agreements. Now, pay-for-delay agreements have been investigated in the US and in the EU. And as of 2014, there were news reports in India saying that the Competition Commission of India has taken suo motu cognizance of potential pay-for-delay agreements happening in India also. My question to you is that while these agreements may be investigated under Section 3.5 as otherwise anti-competitive and may be allowed if there was some potential justification for protecting the right to exclusivity, nonetheless, especially in India, where India is termed as the pharmacy for the poor world, shouldn't there be a more stringent sort of, and you see, it's been almost 4 years, it will be 4 years in August 2018 since the investigation apparently started. Shouldn't there have been anything done with respect to pay-for-delay settlement agreements if they were happening in India? And it's not as if they don't, because of the companies investigated in the US and the EU, there have been Indian generics that were investigated and fined. So my question to you is on pay-for-delay settlements and how they should be investigated in India and the IP competition interface there. Thank you.
Anyone want to step ahead and take a shot at that? Please keep your comments brief, because I want to make sure I get to all the questions in the room.
And Dr. Gary can correct me if I'm wrong, those news reports were rumors. There is no case pending in CCI on pay-for-delay. Those matters were settled and were negotiated and finally settled under mediation. At that time, when the news reports were floating, at that time party were in mediation, which was monitored by the division bench of the Delhi High Court. And from my experience as a litigator, I can tell you, in India, no patentee will pay a defendant to settle the matter. In India, no party has an incentive to pay for settling a litigation. Secondly, the pay for delay, which is more prevalent in US, is in the context of the legal regime which is prevalent there, that Hodge-Waxman Act, which gives the first challenger as the 180 days exclusivity. So there the patentee has an incentive to pay and settle the matter and create a duopoly in the market. So there will be only two players. Instead of one player, there will be two players competing in the market. Still, those two players can charge excessive pricing, and the patentee can avoid a challenge to validity of its patent. India, we don't have that provision, so there is hardly any scope for pay for delay in India, unless is a very important patent for someone and the defendant has a very good challenge to that patent. But till date, I haven't seen any such situation in India. And
Okay, great. Yeah, the gentleman, yeah, right there.
Me?
Yes, please, thank you.
Hello.
I think pay for delay would also depend upon pay for delay would also
Happen who's paying for the delay. So is it an Indian company that the commission would want to investigate, or is it an outside company which the outside agency would want to investigate, and who is the beneficiary? Whether the commission would want to spend time dealing with a beneficiary who's just accepted a payment for no breach of competition law. So I think that's why the competition commission would find it very challenging to bring a case for an investigation and continue that investigation for a very long time.
should pay for expediting the dispute to defend it.
Yeah, you please.
Hello, I'm Shekhar from Jawaharlal University. I have one question for ma'am and another on a comment on SSC, and would like to take anyone of the panel. Anyone of the panel could take. One thing is that law is always dependent upon the values and the modes of the society somewhere. So if we look at the competition, so isn't it the competition is, instead of the prices, it is about the values. Like if one person in my country is going with the value system of the country, another person on the name of trade secrets doing something which is not going against my values, going against the values of the country. So that makes it, they ask him to disclose your trade secret so that I could assess that your method is not going against the value system of my country. So, I mean, I wanted to take a comment on the competition law in terms of the values, not in the terms of the prices. And second, about the standard setting organization. When we look at the standard setting organization or the organization who decide about the standard essential patents, they are mostly the consortiums of the big companies. And they all are mostly the practicing agencies. So now there is a problem when a practicing agency decides to go out of the business and hold on to the patents, like what happened in the Ericsson. So how do you see this problem when a practicing entity decided to become a troll?
He says a practicing entity has decided to become a troll. So, anyone want to take that question?
On the standard settings organizations, and it's a very good question. Thanks a lot, because it helps clarify some misconceptions on standard settings organizations. Number one, the statement that you've made that standard settings organizations are only formed by big companies is factually incorrect. That's just not true. Standard settings organizations have all sorts of companies. Some of them are implementers, some of them are inventors. They're fairly open. The contributions come from a wide range of companies. We've conducted studies We've conducted studies that looked at, the ability of the smaller companies to contribute to the standard settings organizations, and they absolutely can and do contribute to the standards. There is obviously a limitation for the large contributors, which is you need to invest quite a bit before you obtain a return on that investment. And obviously companies that have the financial muscle to undertake that are more limited. But that's not to say that the other companies cannot contribute. If somebody has a good idea, it makes it to the standard. That has been proven time and time again. On your second point about, so what happens if somebody becomes a patent troll? So a patent troll is a term I don't favor, but I know it's commonly used, but let's refer that to a non-practicing entity. So for everyone's understanding, it used to be the case that IP was used defensively. So I would have my IP and my competitor will have another set of IP, there was limited litigation because if I was attacked, could use my IP defensively and vice versa, and we could, sort of negotiate a more reasonable outcome. That disappears obviously when the company that I am litigating against is not an implementer, because even if I have IP, then I cannot use that IP against the other party because they don't implement, and therefore I am defendless, and that has generated some agreements that are pretty painful actually. And by the way, even large IP holders like Qualcomm suffer from these non-practicing entities as well. So the fact of the matter is, the short answer to your question, what happens if a company that it was first an inventor and an implementer becomes a patent troll and stops implementing the technology? The short answer is nothing. If I have a standard essential patent and I try to seek an injunction against you because I am charging you a price that you think is unfair, it's something that I'm not going to be able to get away with. There is settled case law around the world that in most places that I know around the world, if I don't want to pay you my license, then all I can do is I go to court and we'll litigate and somebody will win. So the fact that company is not an implementer I don't think it's a game changer. That's not to say that we don't all suffer from these non-practicing entities. We do. It is, however, I've heard, I'm not saying that you, I don't want to put words in your mouth obviously, but, and I'll conclude with this. It is not because there's companies that are able to, if you want to rig the system, that should be a reason to kill the entire system. The system does work. It works pretty well.
Dr. Gauri, did you want to respond? Or?
Well, I suppose he wants me to respond.
Yeah.
Just a quick, the two questions are linked. You brought in this question of values, you brought in this question of trolls. And why I think it's interlinked is because of our mindset to think anyone who's doing business is a very sneaky person who's sneaking his way through. And this is a mindset that really has to change. Because it has to function on certain rules, it has to function on certain trusts that are coming up. And that CCI would take up the cases of trolls. It's again a larger process of how you're doing the investigation. When you look at it, are you going to look at an NP, or are you going to be carried away by the general populist approach that is taking place? Or are you also going to have this sneaking suspicion? Because face it, the most important role of CCI, which is what I've been saying right from the beginning, is to create modern markets. And what do I mean by modern markets? I mean markets that function on rules. The games have to be laid out upfront and has to be followed. And it invariably happens that when competitors do come to CCI, they're also playing a slightly sneaky game. So that's all I have to say.
Do you want to weigh in? Please keep it brief because there's one more question that I want to get to.
There's a difference between troll and non-practicing entity. NPs are those companies who are doing research and development and creating technology, so they can't be called as a trolls. Trolls actually is basically developed in the context of those companies who purchase someone else's IP and do licensing. Secondly, an NP has much more incentive to offer a very reasonable price for its technology in comparison to an entity who is competing with its licensing downstream market. NP is not competing in the downstream market, it's in the technology market. And the only source of revenue is the business of its licensee. The more the licensee will sell, the more the company will earn, the technology owner will earn. So technology owner will never want that it charge that much amount of money that licensee's business become unviable.
Wonderful. I want to make sure that I get to, I know there's several hands, so if you don't mind, I will ask each one to ask your question really briefly, and I'll let the panelists respond to the questions, okay? So I want to make sure that all the questions are asked, okay? So can we just, okay, go ahead. Please just ask your question, and And please keep it brief, because we have only about 5 minutes left.
Yeah, hi. So, in the case of Ericsson versus CCI, Justice Bakru emphasized the fact that the Competition Act and Patents Act are both special legislations, and the court should try to interpret them harmoniously. So, my question to you is, what if the same is not possible? What if harmonious interpretation of both the acts is not possible? So, which one will prevail, the Patents Act or the Competition Act?
I'll actually let everyone ask their questions, so and then we'll have a few minutes for responses. But go ahead. If you need to make some notes, then go ahead, because I'll give you some time to answer briefly. Go ahead.
First of all, I extend my welcome to the dignity of DICE. Myself Hitesh Valswal, and I am a member of Company Secretary of India. And my question to the entire panel is this, that although the statute itself has restrict the right in different IP sectors, just like 20 years in patent and 60 years in copyright and other acts, my belief is this, that is it not a right time to reduce this limited time right in interest of the public? Let me explain it with a small example.
I think panelists have heard about durations of IP rights and whether they should be tailored. I think they're quite familiar with it, so please keep it brief.
Yeah, I have felt in my practical life that what actually happened, that let's say one of my client has created a patent and he got it patented, and now he has further innovated on the same process or same thing, and now he is holding that further innovation for getting it patented only just with a reason that he feels secure that at least for next 20 years this will be my right, and first I will explore this and then I will get it registered in future.
We got it. We got the picture. So yeah, go ahead. And please keep it brief. I want to make sure that everyone has a chance to ask their question.
I got your point, sir. This is Prateek, and so my question to you is that while you were talking about hold up and hold out, it's clear that one is looking for a patent because one has worked over it. Second, that if that patent is brought to the level of an SAP, it will make him available, like his technology available to the globe, so his finances are going to rise. So I think it is wrong, it will be, at some point of your presentation you said that nobody would like to have his business being ruined because of the high price at SCP. But I think the objective is already achieved once the patent has reached to the level of SCP. And that's precisely what a company will try to target, because patent and then SCP is what else do you want in the world? Thank you.
Got it. I just have time for just one more question, so just...
Good morning. Good morning. I'm Priyanka Jain, pursuing PBA LLB in 5th year. My question is it legal for people selling car manuals in eBay or any online platforms? And the second question is, if all the trade secrets would be shared, will it not win the actual competition in the market? That's it.
Sorry, we didn't get the second question.
Second question is, as Gauri ma'am has explained in a presentation, that if all the trade secrets would be shared, but I'm asking to the panels that if all the secrets would be shared, trade secrets would be shared, will it not win the actual competition in the market?
Yeah, so thank you, ma'am. I'm going to give the panelists a chance. Please keep it brief. You only have a few minutes left. So whichever question you want to respond to, go ahead. And so I'll just start with Dr. Gauri.
I think the question that was raised on the Delhi Baku judgment was answered well by Ashutosh. He really put across the argument well. And I really wondered why the CCI is going to take it up. My own feeling, and I want to fathom this answer, is that that CCI would really have to come up with a set of rules and a sort of guidelines which have to deal with how IP will be treated here. We have got too dependent on the approach taken by the European Commission, but we are not Europe. So, the ground rules are very different in this country, and perhaps that is why it was said that CCI should take it up. So we'll wait and see what happens. For the other question, I didn't say trade secrets should be shared. I thought trade secrets should be respected. It's only that CCI in its judgment has decided that trade secrets should be shared, and this is something that was taken up later by my other speakers. Was there any other question? No, I don't think.
Mr. Ramos, do you want to weigh in on any of the questions?
But I have to embarrassingly admit that I didn't hear the question well, so I apologize. I don't...
Yeah, that's fine. Mr. Couturier, do you have anything you want to respond to any of the questions?
Quickly, regarding exploitative prices, the high prices of SAPs, right? As I said in my presentation, I don't see there is a difference between SAP and other IPs, right? This is what you were asking with respect to exploitative prices. They need not be recognized that they have become essential facilities, only then you can apply competition law. I think that's too harsh a standard, right? And in order to touch that standard, a lot of, you leave the gap open to which consumer welfare laws can happen. But as I said, exploited, it's a tricky business, In principle, they all have it. They have it because it's all a democracy road. You can force the innovator to come to the table and negotiate it with the implementers. So far as the practical applicability is concerned, it's very difficult to implement in practice, right?
Okay, do you have any comment very briefly?
Harmonious construction possible, then which act will prevail? I think for that, just as Baku said, we will check, I think it's para 151, that in case there is a irreconcilable conflict between the two acts, then patent act being a special statute will prevail. But in that case, he said that he can't see any such kind of a conflict, so competition commission will have a jurisdiction. That's what his ultimate finding was. I think his question was that you want, if I'm not wrong, you were saying or suggesting that all these SEP owners, they somehow attempt, or their motive is to create technology just to convert them in standard essential patents and then create a hold-up situation. That's what you want, or you wanted to ask?
May I?
My question. I really don't think we have a chance to go back and forth. So, Mr. Mehra, did you want to weigh in on anything really briefly?
Yeah, I have a very limited question whether car manuals can be sold online or not, and the answer is yes. There's no law that prohibits car manuals being sold online. So, yeah.
Okay, great. I want to make sure that we have time for the coffee break, and I want to make sure that we have time to listen to the other panels. IP and competition law is a terrific topic, and so I apologize for a couple of other hands that I did not get to, but I'd like to thank the panelists and for a terrific talk.
Before we break for coffee, so please present them to
Thank you very much. It's photo time.
We'll resume at 11:55. 50. 11:40. Okay.
That's okay. To be oh my God. I just couldn't say it.